presenter coming,
Thank you.
who's here now, to do a presentation at 6. I'd like to get started, so I'll call the meeting to order. It's 5:30. I sent out the draft minutes via email. I don't see them in this folder. Is that, am I right?
Right.
Okay. So,
The minutes are, but not the.
the minutes are?
Yeah.
Oh, okay. I didn't see them. If you want to review them here. I'll see them.
I don't have them. I got them in my email, though.
Okay. So I would entertain a motion to approve the meeting minutes from the March meeting. So Peggy, thanks. That's one. And do I have a second?
Second.
Don, thank you. All in favor?
Aye.
Thank you. Meetings minutes are approved. Chair report. So I don't have a lot to report. We will discuss in the items for discussion some issues that I will just foreshadow now. One is that, as you know, we voted last month to have Don as our administrator, temporary administrator. And it appears that our motion was not clear enough for HR to understand what we meant by that. Correct. And to fully execute what at least some of us intended for that, in that they have not yet begun Don at the higher pay rate. He's still being paid as a clerk. He has authority to receive the ops reports, which was one of the two kind of critical administrator tasks that were important to getting started now while we're hiring a permanent administrator. But a lot of what Don is doing now, inventorying cases, making determinations about what cases need to go to investigation, which cases need to get ops reports. These are a higher level, some of these, not all, but some of these tasks that he is doing are a higher level than a clerk position. And I think that that's what we had intended when we voted for him to be temporary administrator, to allow him the authority to do that, but also recognizing that that required a higher pay. So what I'm going to suggest, rather than getting into a lot of discussion about whether HR should or should not give us the authority to do what we have authorized, I would suggest we entertain a motion for a more clear expectation of what we want from that temporary administrator role, and specifically with regard to pay. And so that's what I'm going to leave in your minds for discussion. That I think a motion with a little more clarity will tee up whether there's an actual issue with enforcing or executing what we resolve, or whether it was just a miscommunication and a lack of understanding on the part of the city with respect to what we wanted. So that's a primary issue that I'll fight for Don, so Don doesn't have to fight for that himself in the administrator report. The other issue I wanted to bring to your attention is that there is a piece of legislation pending in the council related to Councilor Majoke's legislative advisory committee. So if some of you have seen this in the paper probably, that there has been a group of people kind of organized by Councilor Majoke to meet, discuss issues about the CRB, what could be amended in the legislation, and they have been meeting since about summer of 2024. Don has been a part of that for most of that time, right?
That is correct.
Yeah. So there is legislation now to kind of formalize that committee, which had not been previously formalized with legislation, had not been meeting pursuant to open public meetings law, had not been publicizing their meetings or making their meetings open to the public. And so this legislation is designed, I think, to more formalize that committee. My feeling on that, happy to discuss it more in the discussion, is that the CRB is an independent organization. We were designed specifically not to be a police internal affairs department or a mayor's committee on police accountability, but a citizen review board with independence. And I think we may well agree that the legislation needs amendments. We might even agree with some of the substantive recommendations of this committee. However, it's my belief that this committee, a legislative advisory committee, should be generated from us, designed by us, directed by us, probably with one of us as the chair of that committee, and maybe other members, of course, being welcome to be participating. And it's my belief that that should be, the legislation should therefore be at least postponed, if not voted down, until such time as we're prepared to guide that. We're a new board without an administrator, and we should be independent, not directed by a particular counselor or the council in general about what we should be doing with the legislation. So the council, I think, needs some direction from us. Hey, Linda, welcome. There is a full folder there for you, and maybe next to Don here, but you're welcome to sit there if you'd like.
When I need to get that form from her.
I already got it.
Oh,
I
okay.
grabbed it. So I think the council needs some direction from us, some idea of what we are looking for there, and that's my position on what it should be. That's my chair report. I do know that Ada still does not have access to her email or to the shared drive. I hope you will let me know if you do not, or let Don know. We are really hoping that we have cases to review very soon, and everyone needs to have access to that to be able to participate, so.
And if anyone needs training, they could just stop by the office and I'll walk them through the process of how to look at those cases. So.
Go ahead, Don.
Okay, on the monthly report from as a temporary administrator, okay. As far as data processing in the police department, I met with internal affairs yesterday, and we talked about some some options for streamlining data transfers between the CRB and the police department, because that's becoming sort of a stumbling block in getting these cases up and running. We explored the potential of using what is called evidence.com. It is a web-based application where the data is live data, so we can go in, pull that information in real time. Also, it gives us the option to upload our data, any videos, any photograph, any additional information that the police may not have. With us adopting the evidence.com, would provide, like I said, real-time access to the case files. It would also reduce the need for us to have additional data storage. As you remember, the last time that Lynette was here, we talked about getting additional data storage. That would be a web-based application, so that would save us money. There is a fee for joining that organization, so we'd have to figure out what the cost is and then make sure we get it loaded into the budget so it would be covered. And then all on the billing and invoicing.
May I ask a question
Go
about
ahead.
evidence? So does the police department use evidence.com?
That's the web base they're using right now.
Okay.
So all the data is archived and stored out there. So we would have access to that, any of that data that's out there. So
Is it not possible for us to become just a user of their account so that we wouldn't have to pay anything?
I didn't get a chance to talk to them about that. I can talk with those guys about that to see if we could piggyback on, but chances are they probably want us to have our own account.
And they could dictate what our account would have access to through the
Right.
sharing mechanism built into
Yeah,
it?
that is correct.
Okay.
On the billing and the invoices, all the invoices are caught up, paid up, and with the exception of the honorarium payment to Barry, which I'm waiting for the documentation to come back so I can push that through purchasing to get her paid for that. Complaints, as of today, we received 9 complaints. Out of those 9 complaints, we actually have 3 cases that people actually filed and sent back the complaint form. And so I'm working on those right there.
Those 9 are year to date?
Those are year to date since I took the office in January. Go ahead.
No, I'm just asking for clarification. What's the difference between received 9 complaints and then process and returned 3?
And I guess the language is a little off. It should have been, there were 9 people who called in who said
Okay.
they wanted to file a complaint. But out of those 9 people who called in that wanted to file a complaint, only 3 of them actually followed through and submitted a complaint. I think that was on the caseload. Brenda and I talked yesterday about some options on helping to get our caseload backlog up to date. One of the things that we had talked about was that the most time-consuming feature of getting a case to hearing is the investigation, because you have to look at the complainant, you have to look at the complaint, you have to look at the police footage, the camcorders, the body cam. You also have to look at police policies to see whether or not the policy is in line with the complaint. And those are all very time-consuming process to go through. So what we were thinking about doing is that those cases who are at an 18-month period, because that's the point of where the case falls off of the jurisdiction that anything can happen. We were thinking of handling those cases off to our investigator, letting him handle the bulk of the cases that are at that point. And then as we sort of knock those cases off and start learning how the process is for investigation, we'll start doing our own investigation, which means that it's going to be another impact on our budget, because now instead of the investigating company doing 2 to 3 cases, they'll be doing, we're looking at probably 10 cases that they'll look at, get ready for us to bring to the board to do an evaluation on whether or not we should have a hearing on that or not.
Now, does any of the approximately $240,000 that was budgeted last year not spend rollover, or is that use it or lose it money?
Use it or lose it. And we have the budget hearing on April 21st.
So we have until June 30th essentially to use up all of the budget from last fiscal year?
That is correct.
So that does make sense to load up the investigator right now and.
Yeah, with
right?
those, so. And one of the things is that we before we could make any moves or determination on that, we'd have to get a buy-in from the board that we're willing to spend that extra money to get the cases brought up to speed. So we'd have to have a vote on to do that. And then under the staffing and administrative status, I'm currently filling the duties of temporary administrator, office clerk, billing and invoicing clerk, complaint intake staff, web updates, and onboarding for the new members for the CRB board. And I'm awaiting the approval from HR on the salary increase. I had gotten some information from HR that they want to increase the salary by $6, and they would be able to, I'd be able to work up to 38 hours per week, which to me is totally unacceptable on the $6 raise. But the time, having the ability to do up to 38 hours would work well, because we need to get a lot of things in place. So when we finally get to new administrator hire, they don't have all that heavy lifting to do, and we can get that all taken care of for them, or most of it.
I have a question for you.
Okay.
Are you currently able to update the website?
No, I haven't got the permission to do that. I was
Okay.
talking with not HR, but IT the other day about when I was going to get that access to the website, so I can make those changes.
So just know that the city clerk can and is updating our website at my
Oh,
request.
okay.
So that, I just thought that was something that we could take off your plate. And
Oh,
so,
okay.
so like they are putting the minutes up, once we approve them, they put the minutes up, they put the agenda up, they have all of our bios and terms, they have been updating at my request.
Okay, great.
To take that off of your plate for now, when I knew you were only working 20 hours a week.
Okay, great.
And I
that's-
appreciate them for doing that.
Yeah, that's the end of my report.
Well, I just want to say that I've witnessed all that you do, and he walked us through his ideas for the AI assistance with the investigation, and it's incredible the time that we can save, or the investigator can save, the administrator can save, at getting things sped ahead and not being delayed as it was before would be awesome. So I really appreciate everything that you are doing, and I hope that someone, the powers that be, can give you what you need.
Let's start with that for discussion.
Yes.
What would be, do you know, Don, if you know, what the hourly increase, or what the hourly rate would be if you were being paid in accordance with the current salary for the administrator?
Okay. That, I think, is like $45 an hour.
Okay? You're currently getting paid $20 an hour.
24,
24, and they're offering you 30.
right.
Okay.
So, and then, you know, and the 45, if you think about it, it's not only the admin position, but the clerk's position, the secretary position, the billing position. So it's like 5 different jobs that I'm doing there in the office to make sure it's up and running and on schedule.
So looking at the requested budgeted amount for the program coordinator for next fiscal year, 72,377 divided by 52 weeks in a year divided by 40 hours a week is 3480 an hour.
Okay.
And how many hours a week are you willing to work?
25 a week, but with the option that I can go up, if there's something that needs to be done, then I'm not straddled into just those 25 hours.
Up
So
to
the-
28? Or up to?
It's up to 38 hours.
You would be willing to work up to 38?
Yeah, up to 38
Okay.
hours.
Well, what you said, Josh, we also, the data analysis, if you divide up 51,000, the legal secretary, 45,000, you put all those salaries together, it's a nice asking price for 45.
But yeah, he would have to work consecutive full-time jobs to be able to do all those jobs, so I don't think that's a
We don't,
reasonable.
it's just temporary. We're just trying to
Yeah.
get things going
Right, we're also
temporarily
3 months
until,
into the year with no salary expenditures too.
yeah. So not trying to say you're gonna run everything always, but we appreciate what you're doing now, and until we have our staff in place, we need you to continue to do that.
And probably even once the staff starts, it would be nice to have some overlap. In my opinion, it would be
Yes.
nice to have some overlap.
Yes.
Do we think it would be a hard sell to go to HR and say we want the pay for this position to be more than what the permanent position is going to be? Is that something they would listen to, or?
Well, because, you know, and the way they framed it is that it wouldn't be a temporary admin. It would be an office. I can't remember the terminology that they use. But it would they could only sustain that for 3 months. After that, then we'd have to come back to HR if it was longer than 3 months. But I don't perceive it being longer than 3 months. Once we get the admin on, so.
And we could authorize it for another month or 3 months at that time.
Right.
Right? I think what they're saying is they want authorization for a period of time. So I would entertain a motion for a set hourly rate of,
How many hours is the new administrator gonna work?
So it would be, I guess,
35?
yeah, 9 to 5.
but 35, right, with an hour lunch? Is that the city? That's 37. 37.
7.5,
So 37 and a half,
right?
and you're just the interim director until the new one's hired, or
Right.
make it clean,
Yep.
justifiable?
And you know, the thing is that whoever the new administrator that comes on board, there is a huge learning curve that they're going to have someone in the office to help them walk through all the procedures because, you know, it wouldn't have been so bad if the entire staff hadn't left.
Right.
You know, because they could have pulled some of the weight. But when you have nobody in there, because whenever the new administrator gets in, she's got to hire all the new staff, the executive secretary, the data analytic, the outreach. And one of the things that I think that should happen is that we should budget for a second investigator.
Well, we had in last year's budget a full-time investigator. But my recollection is that had never been written by the county. There's like a county process. Once you get it approved in the budget, the county has to write the civil service or the posting for it, and that can take up to a year. So we had a full-time investigator position budgeted for this past year, which I believe it may have even been posted around the time that Raina was.
She interviewed people.
She interviewed people?
Yeah.
Okay. So that is absolutely we have to do Freeland for this period of time.
Right.
I don't even know if Freeland was someone who was considered as a full-time person. I don't know nothing about that process, but our budget should reflect that we were supposed to have an additional full-time staff person hired as our full-time staff investigator.
Because the way the process was running when that was in office was that she would do part of the investigation. She would do several of the investigations. Anything that she couldn't get done, that would then be funneled off to Freeland investigator. So they would do some of the cases. So between the two of them, they were doing all the investigations for the CRB.
Yeah, I mean, as you see on the budget, there's actually 4 additional positions besides the administrator, which they're calling the program coordinator. That investigator is a full-time position there. In the meantime, hopefully Freeland can do it. So I would entertain a motion. Is anyone prepared to make a motion with respect to our resolution with respect to the pay for the temporary administrator and the number of hours that we are authorizing him to work?
I say he's the de facto administrator with all benefits and the whole array of responsibilities.
So you're looking for 45 an hour, set at 25 hours a week, but up to
38.
Up to 38?
Right.
37 and a half.
Oh, 37 and a half, whatever.
Yep.
And that was what I couldn't understand when they said you could do up to 38 hours. And I was
That
saying,
make- well, but- so the other thing to take into account is that Don is not receiving benefits.
right,
And I think that should be taken into consideration with respect to the hourly rate, because the hourly rate considers a whole benefits package in addition to that salary. He's not getting it. I think for that, a $45 an hour rate, especially at a lower number of hours than full-time most weeks, I think it's justified, and I would look for a second to that
Second.
motion. Linda seconds. All in favor?
Aye.
Okay.
I don't think I formally made the motion.
Oh,
So
go ahead.
I'll formally
ahead.
make that motion.
Let me slow my roll.
So I will formally bring a motion that Don be paid $45 an hour in a position of interim program coordinator for 25 to 30, minimum of 25 hours, up to 37 and a half hours a week at his discretion.
I second that motion.
All in favor?
Aye.
Okay. Thank you, Josh, for formalizing that. And I think the specific term is temporary administrator. And I will get the minutes out to everybody, and then I will forward it to HR and find out what needs to happen in order to effectuate our motion, which I think is clearer than the last time. And we'll see if that, in fact, was the problem, if there is a different problem that we will then deal with. With respect to the legislative, and I know we have 5 minutes before our training is set to start. So is there any discussion, questions related to sending cases to Freeland for investigations in this meantime? Does anyone need additional clarification on that or additional information on that
So
issue?
is the long-term plan to hire an investigator?
Yes, that's what our budget, so, and that's a good point, thank you for saying that. So April 21st is our budget meeting. Everyone is welcome, it's public, it's here. I'm assuming that the counselors will be here to ask questions of Don and I as best we can. I'm sure that they will have lots of questions that don't pertain necessarily to our budget, because this will be an opportunity to get some people from the CRB in front of them.
April 28th?
April 21st.
21st.
At
What-
1 o'clock.
1 o'clock.
Yeah. Everyone is welcome. So, so the issue, yes, we have money in our next budget, just as we did this last year, for a full-time investigator. Right now, the way that I see it, we have money left in our budget to do investigations and for the salary line for the investigator, which we never hired last year. We have cases that need to be investigated. John and I fully acknowledge that it may be that a more experienced, trained-up administrator would look at some of these cases and say, I don't need to investigate it, or I can investigate it myself. But we are looking for some help. We are looking also for some continuity from a person who's already done some investigations in the past. And we would like to say, if there's any question about whether there might have been misconduct, let's send it to an investigator. It may mean we have more hearings than we need to have, because we need to get all the information out at hearing, and it may turn out that there are cases where we have hearings and there isn't misconduct, and we could have known that earlier with more experience, but
Is it possible to use the leftover budget from last year to purchase a retainer from the investigator?
I don't think so. I think that question has been asked before, because just like you're paying for future, yeah, we could pay for subscriptions, but I don't think that paying for future labor is within that, in advance of, yeah. So I would say, and Don is going to talk to our investigator right now to see how many cases he can take to try to do as many as possible before the end of June, so that we can get started on that, but so I would entertain a motion to authorize Don as temporary administrator, and also me as chair. I'm happy to be part of those conversations with Don, to authorize us to send number, at least, let's say 20 cases, up to 20 cases per month to the investigator. We don't know if he's going to be able to handle that many, but I would entertain a motion to authorize that use of our CRB budget to get some investigations started to move cases forward.
I second it.
I can't make the motion,
Oh.
so someone else has to make the motion.
No, I can't make the motion. Vice Chair.
Yeah.
Are you gonna do it?
So moved?
Josh, thank you. Thank you. A second? Thank you, Peggy. All in favor?
Aye.
Aye.
Thank you. All right, seeing that it is just a few minutes before, I just want brief committee reports. I will move the public comment to the end of the training that we have, but brief committee reports, and it's totally fine to say we haven't met yet, or I don't have any updates at this time. I'll start with community outreach and public education. Anyone?
Who's the chairman of that committee?
Definitely Otto's on it.
I'm on that one.
Okay, we don't have an update. How about,
I'm on training and government relations, I believe.
okay, committee on board development and training?
We don't have a formal report. Elise and I spoke on the phone yesterday. We're getting the wheels in motion. We've spoken to some other CRBs in the area. We're hoping to get some of their training materials that we can start to build some formalized processes off of, but no formal report at this time.
Thank you, Josh. Committee on government relations? No update?
No report.
Committee on police relations? I know that's Linda and Mike and Joyce, excuse me. Any update, except that that meeting is coming up?
We got a meeting coming up, yeah.
Okay,
What date, what is that?
April 8th.
Okay,
thank you.
and where's that meeting gonna be held
At
at?
the police department, second or third floor. I'll let you know, I'll give you
Okay.
information.
Great.
And committee on operations, I know there's lots, so what can you tell us that you can tell us in a public forum?
We have 2 finalists.
Fantastic.
That's all I'm gonna say. Yes, and we're going to have second interviews next week.
Thank you very much.
You're welcome.
Committee on hearings, that's myself and Mike, and we do not have any updates yet. Seeing that it is 6 o'clock, although that clock does say 5 o'clock, I'm going to ask Connor to please train us, tell us what we need to know about open meetings law.
So yes, my name is Connor Ward. I am an assistant corporation counsel with the City of Syracuse Law Department, and today's training is on the open meetings law.
Excuse me,
You're gonna
Connor,
have to-
does everybody have a copy?
Yes, so there's, yeah, I passed them around,
Okay,
and there's one.
Sorry, they're not. Try to print out black and white. They just did grayscale.
Can you just make sure you speak up a little bit so we can hear
Oh,
you?
yeah, would you mind coming to the table so you could be on mic'd? Because I'm afraid that the folks on YouTube won't be able to see you over there and won't be able to hear you. Either there or you're welcome to sit, we can scooch around.
Yeah, either or, whichever's easiest for everybody. So yeah, again, my name is Connor Rourke, Assistant Corporation Counsel with the Law Department. And so yes, for this training, it's on the open meetings law for anybody that didn't hear. So yeah, so the purpose of the open meetings law is, it's to have open meetings, of public bodies, because, transparency is, important, and, the public has the right to know what their public boards are doing. Right there is just the statutory definition. Don't want to bore you guys with going into the weeds with that. So applicability, obviously, because I'm here, it applies to the Citizens Review Board. And again, that's, more statutory language that you guys probably don't want me to read all the way through, because it just kind of explains that all. But so obviously it applies to this board, but what does it not apply to? It does not apply to judicial or quasi-judicial proceedings. An example being the panel hearings that this board would oversee, deliberation of political committees, conferences, and caucuses, any matter which is confidential under federal or state law, meeting, with the board's attorney, that would be under attorney-client privilege, or anything maybe to do with like HIPAA, anything like that. Again, receiving legal advice from the board's attorney, and political caucuses. Public notice. So notice of the time and place of the meeting must be scheduled at least 1 week prior thereto, and shall be given or electronically transmitted to the news. Shall be conspicuously posted in one or more designated public locations at least 72 hours for such meeting. Looks like it's posted on the CRB's website, so that's good. Yeah, so let's see here. Yeah, so that's just more on the locations and where it should be posted. Video conferencing is an option, but just reading through the bylaws, it hasn't been adopted by the board yet, and I'll get into that later in the presentation, but I probably won't go into it too deeply just because, as of now, it isn't really applicable to the board. So public meetings. So every meeting shall be open to the general public except executive sessions of that body, which may be called and business transacted thereat. All reasonable efforts shall be made to ensure that meetings are held in facilities that permit barrier-free physical access to the physically handicapped. A public body shall provide an opportunity for the public to attend, listen, and observe meetings in at least one physical location at which a member participates. All reasonable efforts shall be made to ensure the meetings are held in an appropriate facility which can adequately accommodate members of the public who wish to attend the meetings. Any public meeting shall be open to being photographed, broadcast, webcast, or otherwise recorded and or transmitted by audio or video means. So if any member of the public comes in here and wants to record the meeting, they can. It's under my understanding it's on YouTube, so that's good. And then any materials that are going to be voted on, ahead of time, they must be made available to the public for inspection with at least 24 hours of the meeting. So the agenda generally. And just continuing that, if the body has a website, which this does, records available to the public, as well as any proposed resolution, law, rule, regulation, policy, or any amendment thereto that is scheduled to be the subject of discussion shall be posted on the website to the extent practicable at least 24 hours prior to the meeting. So here is executive sessions, which is a little more tricky, a little more sensitive. So an executive session is any portion of the meeting which is not open to the general public. And for a, to go into executive session, someone needs to make a motion, needs to be seconded, and then a majority of the board must vote in favor of entering executive session. Executive session is only available for the matters listed below, matters which involve public safety. So I don't know, maybe for this board, like timing of police routes and patrols, I don't know. And any, undercover, agent or anything like that. Anything that involves a current or future investigation of a criminal offense. Anything about current or pending litigation, negotiations on collective bargaining agreements, medical, financial, credit, or employment history of a particular person, or the appointment, employment, promotion, motion, dismissal, suspension, dismissal, or removal of a particular person or corporation, and the preparation or grading or administration of examinations, and the proposed acquisition, sale, lease, real property, or anything of the like, because you don't want to be negotiating, against yourself in front of the public on that. And again, those are the only matters that you can go into executive session for. Anything else risks an Article 78 proceeding, which is not what you're shooting for.
What's Article 78, Connor?
Article 78 is a proceeding that can be brought by members of the public when they feel that their rights are being, infringed upon by the government. So in this situation, going into executive session to discuss something outside of those reasons listed, and remedies of that, which I do have a slide at the end, but since I'm on it, so I'll just say it, is that if there is a vote taken on something that is not permissible, and the board didn't reasonably believe that they had the right to take that vote, then the court could overturn that vote. They could order additional trainings, formal reprimands, that type of stuff in this situation. Article 78 encompasses other things, but for our purposes, that's what it does. So executive sessions is generally just the members of the body. However, the board can have members of the general public attend if they want to. I guess an example of that would be, if you had a contractor or investigator, or someone that has a specific expertise or something that could be of use in that discussion, which is for those very limited circumstances listed in the slide prior. You cannot take a vote on any actions where public monies would be expended in the executive session, because people have the right to know everything that goes around spending public monies. Minutes must be taken during any executive session where there is a formal vote, and they must be posted within 1 week of the executive session. I'm aware that at the start of every meeting, you vote on accepting the minutes of the prior meetings. However, with this type situation, the minutes posted can be marked as a draft and then formally adopted at the next meeting. Executive sessions should not be scheduled. They should just kind of come up in the meeting. And ideally, they should be at the end of the meeting because obviously they're away from the public and, you don't want just the members of the public just sitting here while you guys are in executive session. So it's courteous to have it at the end when practical. Again, so when you're entering executive session, it's required to state the reason. There's the example that I kind of said prior, but so it can't just be, we're going to enter executive session to discuss personnel matter. You don't have to go all the way into naming, the employee, but, for my example there, you move, or I guess, whoever makes the motion, moves for executive session to discuss potential discipline of an officer, and then someone seconds that, and then, it's voted upon. If a majority approves, then you go into executive session. You do not need to go into executive session to discuss topics covered by attorney-client privilege, as that is exempt from the open meetings law. And here's just some
Wait,
more.
can
Sorry.
I don't understand that. So if like, let's say you were going to come and you were going to give us advice about some issue, how would we do that if it wasn't to enter into an executive session?
You wouldn't really, you could kind of just take a break because that's like attorney-client privilege is completely separate from the open meetings law altogether. So I guess you could go into executive session for that, but you don't have to. You could be like, all right, we're going to take a break, go talk to the attorney, come back.
I have a question also.
Sure.
So being that we're working on different cases and stuff like that, so are you saying that that's not a thing where we could go into executive sessions to view cases, et cetera? Is that not view, different cases, the stuff that we have to put in, so that should not go into executive session?
I guess, can you kind of provide an example of reviewing the cases? Because I'm not as familiar with the workings of the CRB.
Yeah, so one of the things historically that we've used for executive session is every time there's a case that needs to be voted on for a hearing, in order for it to go to a hearing, the board has to vote. But in order to do that, we have to call it. I mean, we could call it the 00712 case, but we might disagree. Linda might say, I don't think it should go to a hearing, and Josh might say it should. And we're going to be discussing about the details of the case. And so historically, and also as a shorthand, we might say, oh, and this is the Josh Carroll case. This is the whatever the complainant's name is case. So we have historically gone into executive session to discuss the details of the case in order to come to a decision. That's not specifically in one of your exceptions.
Well, one of the bullet points is information relating to current or future investigation or prosecution of criminal offense. It might fall under that. That's a pretty big umbrella.
Not, but let's see. I mean, is there interpretation? I mean, what is your interpretation of that?
So I kind of interpret that as kind of like a personnel matter type situation, because if it's regarding the discipline of an officer, then it could fall under that, and then that could be, it could fall under executive session, but again, you could say, like my example, you wouldn't have to go into the exact detail of, Officer Smith or something like that. However, you couldn't throw all of the officers that happen to have discipline, any cases upcoming all into one. You'd have to be like, all right, going to executive session to discuss this one, come back the next one, because otherwise the officer, you can't just throw a bunch of topics out for executive session because the public has a general right to know of what's being discussed. I mean, you don't have to, oddly enough, you don't have to get into super details like the officer's name or even the case number, but you do have to say, I guess you could just do.
Was there no way to do a blanket? Because sometimes we may have 3 or 4 cases that we need to review. So you're saying that we would have to itemize each of those for executive session, or we could just say the board is going into executive session to discuss cases 1 through 5, or
I think that would get into particular enough detail. I could, any questions I can circle back to you all to, provide greater detail. But like down here at the bottom of the page, like you can't just throw a bunch of topics out there. However, in that type situation,
because the general topic would be case discussion.
Related to officer discipline.
Right.
yeah.
On only that topic. So
Yeah, I think
that's
that, I
specific
think that
enough.
could be, yeah, I think that
Yeah.
could be specific, my goodness, you know what I'm trying to say.
I don't think they understand, there's no time to discuss a lot of the cases, and that's one of the things that the executive session has been used for, probably prior to this new rebuilding, but that we go and discuss, because monthly, we meet once a month. And if they're not discussed within some form or at some place, then they don't get, it's really gonna get behind. So is that something that could be looked at in a matter where it's included in that? If that's a proper protocol, is that something that we need to try to change legislatively? And where, because if it's not.
I think Connor's saying, I mean, his legal advice to us is that we are able to go into executive session to discuss cases, and what the motion would be, we're gonna discuss discipline of officers pursuant to some number of cases that we're going to vote for here.
Title it under that.
Right.
That's what it is, I mean, that's not like some secret code word, that is what we're
Right.
doing, yeah.
But I see some of the stuff, it seemed like it would cut out some of that, so in reading some of it, so, okay.
So then, along with what Elise is saying, is that, so we come up with the motion to do the case review. But there are certain other things that need to be discussed in executive session. So we would have to highlight each of those items, saying that, we'll have case discussion, we're gonna have this, or do we have to go case discussion, then come back and then make a motion?
Yes, because, it has,
that's
like,
time
it's a little clunky, but I think the main purpose is just to kind of make it clear and not just kind of throw just an omnibus, kitchen sink, so then no one really knows what's being discussed. So
I think it's rare that we would have multiple things.
Yeah.
We might more now at this time, although I don't think for this meeting, but we might at other times have both cases and administrative, the hiring and firing of a particular person, things to discuss. We would have to come back.
video conferencing, which, I put all this in here before I went through the bylaws and realized that video conferencing doesn't apply. But, if you guys ever want to get into the video conferencing, here's the kind of the rules for that. So I guess I'll just, I got 10 minutes left, so I guess I'll just kind of skip through that.
Let me make sure I understand that on the video conferencing. You're saying that the board could actually meet on Zoom with the public having access to the Zoom, or is that not what we're talking about, video conferencing?
Yes, but the video conferencing can only really be used in extreme circumstances. If someone's ill or, they have a family emergency, it's not meant to replace the physical meeting.
And would we have to specifically authorize video conferencing in our board's bylaws in order
Yes.
to even allow that?
Yeah.
In extraordinary circumstances. So we don't have that now, but we
Yes.
could consider that as a legislative change if we wanted to.
All right, so we're going to minutes. Minutes must be taken at all meetings, which, they consist of a record or summary of all motions, proposals, resolutions, and any other formal matter formally voted upon. And, they must be taken at executive sessions as well of any action that is taken by formal vote. And it should consist of a record of the summary of the final determination of the action, the date and the vote, how that breaks down, who voted yes, who voted no, because, it's a formal decision and, if it was in the public, public meeting, then everyone would be able to see, so it kind of tries to preserve that. Minutes must be available to the public in accordance with the provisions of the Freedom of Information Law, aka FOIL, within 2 weeks from the date of such meeting, except that minutes of executive sessions must be available to the public within 1 week from the date of the executive sessions. Like I said prior, those can be a draft until they're officially voted upon. And they must be posted on the board's website. An unabridged video recording or unabridged audio recording or unabridged written transcripts may be deemed minutes as well. So the enforcement measures of the open meetings law. Any aggrieved person may seek to enforce the provisions of the open meeting law by commencement of an Article 78, as we discussed prior, or an action for declaratory judgment or injunctive relief. And for the declaratory judgment, declaratory judgment, my goodness, or injunctive relief, that's just trying to prevent the board from doing something or, forcing the board to. So if you were to say you can't, audio record this meeting, they could bring Article 78 saying, yes, I can. And then the court would say, yes, they can, and make sure that's allowed. If the court determines that the body has failed to comply with the open meetings law, they can declare that the board violated the open meetings law and or declare any action taken in relation to the violation to be void. An unintentional failure to fully comply with the open meetings law notice provisions shall not alone be grounds for invalidating any action taken at the meeting. The board may also require members of the public body to participate in training sessions concerning the open meeting law. And they can, if the plaintiff brings the Article 78, they can, and are successful, they can be awarded their court costs and reasonable attorney fees. And if the court determines that a vote was taken in material violation, which is a stronger violation of the open meetings law, or that substantial deliberations relating thereto occurred in private prior to such vote, the court shall award costs and reasonable attorney fees to the successful plaintiff unless there was a reasonable basis for the public body to believe that a closed session could be properly held. And the statute of limitations, Article 78, commences from the date the minutes of such executive sessions have been made available to the public. And that is my last slide. Anybody have any questions?
Do our subcommittee meetings fall under the purview of open meetings law?
Good question.
I would say no, because we're not going to have a quorum of this board at any subcommittee meeting. Any group of 4 of us, 5 of us could meet privately, and that doesn't violate open meetings law, and all of our committees are smaller than that, or that size. So am I right that we would be able to meet because we're not a public board at that point? We're not taking action as a public board.
That sounds right. I could obviously have to dig in a little deeper, but that does sound correct.
The county, all our committee meetings were open, but they were bigger than,
Rebecca, did they meet quorum or not?
yes, for the committee meetings.
Right, for the committee, so
Yeah.
the committee.
Well, actually, our committees were not that big. There were usually 5 of them on each of the committees, and they had to be open to the public. We always had a lot more people in the committee. But we couldn't, well, and we had differences in political parties too, which made a difference for the open meeting. If all of them were Democrats, it would be okay. But if we had Republicans and Democrats together, then it had to be an open meeting.
'Cause I think I have to agree with Bryn, is that if you don't have a quorum of the executive board at the committee, it wouldn't fall underneath the public meetings law, because there's not, the entire board would not be voting on those issues, so,
There's no action you can take if
Right.
there's no quorum.
right. Because then the committee would have to bring the results back to the full board
I
in
don't
order
s-
for the full board to vote on it, so.
I see in our bylaws that the board must keep written meetings of all minutes, written minutes of all meetings and make them available to the public. I think that would cover
It
our
should cover.
subcommittee, but I don't see that all committee meetings have to be public.
I
according to
can
this. But
also.
I would love some more
Yeah, I
advice
can dig
on
into that a little
Yeah.
further, yeah.
Yeah, obviously, right, we're not doing interviews publicly, so there have to be some exceptions.
But isn't that would be elected officials that are meeting in that committee, and we're not elected officials, so I think that would probably be where the sticking point would be.
Yeah, we're a public board.
Right.
So we are not elected directly as the councilors are, but we are public officials.
Right.
So I think the question is a
And I
fair
can-
one, and it would help to have some.
Yeah, I can
advice.
dig
About
on that
impeding
tomorrow.
the function of the subcommittees if we need to post information
Yeah.
about that meeting ahead of time and keep minutes
And it has
and
to be
come here
here.
to do it, et cetera, et
Or
cetera.
someplace else public, and then I would add a layer of administrative hurdle to finding a place to meet that is all those things according to a public meeting. That would be difficult. You are not being captured by but you can comment when we get to public comment. I want to hear you, but we can't hear you, and I want it to be a public meeting, so I want to be able to hear you. I have another question for you, Connor.
Sure.
So if we want to do a retreat or some kind of board training that is an hour, half a day, that our board development and training committee brings, that's important to topics that all of us need to learn about, we're all going to be meeting together. Does that fall under open meetings law? Do we have to have that training in a place?
I don't believe so. I think trainings are, because it's not really discussing business, nothing's being voted upon. It's, a learning experience, yeah.
And we're not going to have an agenda, for board action, we're not taking any votes if we're receiving training. Okay. How far does that go into other kinds of planning or discussion that's outside of specifically receiving training from another person, from an outside person, or from someone here? If Samia is going to give everyone a training, or, Elise was going to give everyone a training.
Yeah, I don't know. I can circle back on that. but-
Any other questions for Connor?
If anybody has any questions later on, they can email me. You have my email.
Okay, yes,
so.
I'm happy to collect questions and send them. We really appreciate your time being here, Connor, and I want to respect your time because it's late and after hours, and I want to get you out of here, but we may take you up on some more advice or information about public meetings.
Sure.
Thank
Well,
you.
it definitely cleared up a lot of things for me, so.
Yeah,
Glad to hear that. All right, well,
thank you so much.
thanks for having me, everybody, and have a good night.
Have a good night.
I remembered one other thing that I meant to say in my chair's report, which is that in our bylaws, in the meeting section, our bylaws dictate that the board shall hold public outreach meetings in each council district, a minimum of once per year, for the purpose of inviting public input or comment as well as education about the board process. District board members shall attend that public meeting, and all board members are not required to attend every meeting, but of course are welcome to attend every outreach meeting. So to that end, one ask that I have for everybody who is a council district appointee, so you mayoral and the at-larges, we're off the hook, but district appointees, please think over the next month, look at what's happening in your neighborhoods, in your council districts, identify, I think to start with, we don't necessarily have to have our own meeting, but is there a TNT meeting, or is there a neighborhood association meeting, or something that you could ask to be invited to speak a little bit about the CRB, to introduce yourself, to say what the CRB does, and please, over the next month, identify something like that over the next couple of months, so that we are out in the community and reminding people that we are here collecting complaints.
Well, you know, and to sort of piggyback off of that, if you're selected by the mayor, a mayor's appointee, we should probably make it a point to make it to each of the district meetings, or that way they know that there are other people other than the representative from their area is available for them to contact.
The TNT would be a really good place to meet, because, you know, because it doesn't matter what the same, well, not the same people, but you can always depend on a group of people showing up.
Yeah.
Without having to make a big deal about, you know, getting out there and putting it out as.
And us organizing it ourselves. I think there's already an audience potentially there. So,
Well, and then also the NAACP meetings, on their monthly meetings, we usually get a large group of people there, so it'd be a good way to bring up the CRB, to let people know that we're alive and well, or at least alive.
I love all of that outreach. I'm just looking specifically at our bylaws. We're supposed to have one in each council district. So if you're having an NAACP meeting in the 3rd council district, great. Then
Okay.
we can check that one. We can check that off if you're going to go do that. Where's the meeting held?
Sometimes we're at Pettit, not Pettit, at Beecham Library, which would be
Okay.
the 4th ward.
Yeah.
So,
Okay, great.
so.
Seeing that we're a little past time, I want to get back to public comment.
I have
And
one thing
Oh, yeah,
before
go
we
ahead,
move to
Josh.
public comments. You had mentioned in your report that Chol might be looking for direction from this board on his legislation. What is that?
Oh, I don't think Chol is looking
Okay.
for any direction.
Okay.
I am sorry if I misstated that. I think the council is looking for some
I
direction.
went to the council meeting this week because I was hearing they were going to discuss this. And they didn't. And I had talked to several of the counselors to find out, you know, what the deal was with it. And they pretty much said, well, it was on the agenda and they removed it from the agenda. And pretty much they said it was not going to pass. They didn't have enough support for it. And part of the reason was that pretty much Chol had picked everybody. And that wasn't, if they were going to do something like this, it couldn't just be him picking the advisory committee. So that I'm sure it's going to rear its little head again, but for now it's off the agenda.
I think it will be on the next agenda, and I think it was only held. So I think that it is ripe for discussion. And as I said, my position is that any advocacy related to amendments should be directed by us, and should be guided and shared by someone on this committee. Because again, the purpose of the CRB is independence from the police, from the mayor, from the council. And I'm happy to entertain discussion about that. At this point, I'm prepared to write a letter, as I've been asked to do, to council reflecting that opinion.
We're not, weren't you on that
Yeah, I was on that.
So does that not reflect part of the board or no?
It's not, no, I mean, what Peggy is saying is that Chol picked the committee, and Chol is guiding the committee. Donna's on the committee. I was invited to be on the committee. I think others were invited to be on it as well. But I do think that the process needs to be guided by and organized by and thoughtfully planned by folks on our board rather than council, which implies that the council is in charge of what we do or what the legislation affecting our board should be.
Well, and to give a little insight into that committee, since I sat on that committee. Basically, what it was an advisory board committee made up of citizens from the city, from different factions of the city. And the way it was supposed to run was that the advisory board was going to go through the bylaws and the legislation, look and see what was right, what was wrong, make suggestions to the legislation and the bylaws. And then at that point, it was going to bring those changes that they felt that was necessary to make a workable CRB to this committee. Then the committee was our committee was then going to go in and give their opinions and their takes on what needed to be changed in the legislation, what needed to be changed in the bylaws. Once that was done, it was then going to go to the councils, the city council, to give their input onto that. And then once it was formulated a complete set of changes, then it was going to be brought to the general population to have their input into what needed to take place or what needed to be dropped off, added in, or whatever. So that's basically what it was just a quasi committee getting together and just brainstorming on the legislation and on the bylaws. So, and by the way, after 3 weeks, I think we got through paragraph 1. So it is a very, very complicated process to go through. So,
And on that topic, I think it's also important that there were voices that were excluded from the process of that LAC, purposefully or not, people who were involved in the initial legislation, people who were involved in the amending legislation in 2011, and I think a comprehensive look at that legislation or bylaws can't exclude people who probably have the most experience. And I'll name Ms. Gwanter as one of those people who, right.
well, and I think what it was is that they wanted to have a new set of eyes on there. Instead of, you can always look at what went on in the past, but then having a new set of eyes on there that's now looking towards the future. And you do need both the past and the future to merge together to come up with a good working plan, so.
This letter that you're sending, is that from you or from the board?
As chair.
Okay, do you think maybe we can you can share that with us, maybe we can all put our name on it, or should we all write our own counselors and counselors we know independently?
I feel comfortable as chair that it is protective of the board in its mission and purpose to ask for the process to be guided by us. I don't think that's should be controversial. I think the counselors that I've spoken to about it don't find that controversial, but they understandably want something on paper that they can say the CRB would like this process to be independent from the council and guided by the CRB and at our request on our timing. And so my intent is to put that, unless there is strong opposition to that, my intent is to put that in writing.
Well, I have to sort of piggyback off of Josh, is that, if you're going to write a letter as a chairman of the board, I think we should all have an opportunity to look at that because, we're all going to be represented by that letter that you're writing. So if you could get it out to us, we can look at it and give our yay, nay, or whatever. That way we have a collective type of process going on with the board. So.
I hear you. I will certainly send it out.
Okay.
I'll have a very short turnaround because and I may or may not take suggestions, but I will absolutely take ideas. And but if people have ideas for discussion, I'd really like to hear that now because I think the legislation is going to be on the next council meeting. So I don't think we have a ton of time. I think it's going to be voted on. It's going to be up by next week.
To my understanding, like Peggy said, the issue was that Joe handpicked everyone, not the fact that there was a committee.
Agreed.
That was the problem.
Yes. And then it's directed by, directed by
Yes.
him. I agree. I think we might even agree with a lot of the suggestions the fact that changes need to be made and what the suggestions are. But the process has to look like it's independent and it's coming from us.
Not a healthy precedent to set, I don't think, of Joel dictate our,
Absolutely.
and Joel's a great guy, I love Joel, but
And anyone on
independence-
council.
Right.
So happy to talk to anyone about it separately. I'm also aware that we are well past when I wanted to have public comment. So I will send out a draft of that letter in the next day or two. Just a reminder, before we go into public meeting, I think we haven't done this before, everyone has, public comment. 5 minutes, and there is no, you're welcome to say whatever you'd like in public comments, but there's no responses expected. We will happily listen, and your responses or comments will be recorded, but it's not a question and answer period for the board. That being said, would anyone like to come up for public comment?
By way of information, at the time that the Legislative Advisory Committee was formed in 2011, there was no functioning CRB to design or lead the revisions to the law. The CRB was non-functional, and that's why Councilor Hunter at the time convened a Legislative Advisory Committee aimed at restarting. You have already restarted. I am personally not comfortable with a committee where there is no one on the committee with prior in-depth historical experience with the CRB. With all due respect to Don, I was thrilled you were on it, but it's not the same as having somebody who has been looking at the CRB in depth for years. I really like the idea of the CRB having a firm idea of what they want to see changed in the legislation before the committee is convened, and having more than one CRB member on the committee. I really do support that. As you know, because I've already given you a copy, the group of advocates that started pushing for a Legislative Advisory Committee in 2024 has come up with a list of possible changes to the law. If at any time you want to discuss that with the advocates, and not just me, there's like 6 or 7 or 8 of us, I'd be happy to make that link. Secondly, open meetings. The way to think about it is if you're conducting any business of the board that is not related to something confidential, it's got to happen here. There is a very limited set of things in his packet that you can go to executive session for. So that's sort of the way to think about it. And also, I can't legally accurately answer the question about committee meetings. What I can tell you is all the committee meetings in the city of the city council are public, and some of them have only 3 members. Most of them only have 3 members. So I would urge you to look into those public notice requirement in relation to subcommittee meetings, although it might be overly burdensome. The budget hearing, 4/21, I will try to attend and observe. There is, I don't think there's a public comment there, but I would urge you to notice the public about the budget hearing, because the public should witness how you are treated by the council, whether there really is support or whether you receive the kind of challenges that the CRB has received in the past, which communicated clearly that the council didn't support you. So I would ask you to put a call out to the public. Article 78. The way of thinking about an Article 78 is it is a member of the public or a business entity or anybody else aggrieved of government action or inaction. It's a motion to force a government entity to fulfill its official function. So it could be an Article 78 saying, your official function is to hold open public meetings. But that's what an Article 78 is about in layman's terms. Last thing, I don't understand why the administrator is being called a program director. This is really an executive director position. It's called administrator, but it's an executive director. And I have to wonder why the salary, whether the salary is so low because somebody in HR decided that they were a program director when they're really at the level of an ED. And I would urge you to consider that the police have a chief accountability officer, and that person was hired at a much higher salary. And I think that the CRB director's position has been misclassified, should be reclassified to reflect what it's really about, and the salary adjusted accordingly, because I'm assuming you're having trouble attracting somebody with civilian oversight experience. I don't know. But that's my suggestion. Program director? This is not a program. This is a
Coordinator,
yeah. I'm sorry, that's mischaracterized. Thank you. Thank you.
Excuse my attire. I'm I'm Dr. Dexter, pastor of New Salem Baptist Church. For the sake of time, it seems like you all have a better, excuse my southern vernacular, I'm a Yankee, but grew up down south. It seems like you all have a pretty grasp of what you all are supposed to be doing. And excuse me for interjecting earlier. I just wanted to just kind of piggyback a little bit off of Barry. It's not a program. It's a way of life that's people are being mistreated. And so with that, we need to be able to equip the community in knowing that you all are adjacent or appointed from different council persons in the mayor's office. So you don't get paid to come and sit through a lot of what you're doing, right? And it's supposed to be compensated to a degree. When you go to other cities, they're compensated, for the time. So 3 people sitting and doing whatever, and then you have to have a quorum in order to do what you need to do. I question that as well. When Joy was at the helm, our church, I did a lot of investigation. We helped win a lot of cases for the CRB along with Joy doing the investigating part, getting video, getting witness statements. It's a lot that we did. So what we're doing now is reinfusing from the standpoint of what we did back in 2013, leading up to 2017 and to the pandemic, is those people that are now coming to us that have police brutality and coming to our church and coming to me and saying, Dr. Dexter, are you able to help fill out documents? I don't trust the police investigators. I don't, trust the CRB because nothing has been done. So we're doing the planning now to be able to kind of get out in the community to be able to share that, yes, we'll sit down and help you fill out the forms and get it back. I know that there is a website that they can go on. Some people don't like to go on the website. So we're working on that. So I'm just here to support tonight. I won't take up time because it is late, but I just feel like you all are doing an awesome job, whatever capacity you're coming from, whatever district you're coming from, but it takes a team effort. And so no one should be dictating how you do this job, and it also should be on notice that those that did not support the job that you're doing should not get a pass and decide what you do and how you do it. That's all I want to say.
Thank you.
You didn't go over your last time, so unless you.
I'm trying.
30 seconds, Barry.
I want you to keep in mind that the Legislative Advisory Committee that was convened in secret, that met in secret, that the public didn't know, the mayor's office didn't know, Don knew, the chair of the CRB didn't know. It was clearly, in my opinion, in violation of the public meetings law. And I think that your approach to it now should keep that in mind, but you also should keep in mind that in the months prior to the formation of this secret committee, there were two proposals coming from Councilor Majok that were designed to put the council more in control of the CRB and its administrator. One of those passed by one vote and then was vetoed correctly by the mayor. But there was an intent within 6 months prior to the formation of that committee to bring the council in control of the operations of the CRB, even to the point of putting the clerk of the city in a position to supervise the staff and the administrator. And so I would just ask you to consider that as the context as you assert the fact that you have more knowledge about what works and what doesn't, or at least by the end of 2025, you will. Thank you.
Entertain a motion to adjourn.
I'll make a motion to adjourn.
Second? Thank you, Peggy. All in favor?
Aye.
We're adjourned.
So I need to be on a committee.
Yeah. What do you want to join, Peggy?
I don't,